Thank you. Good evening. At this time, I'd like to call to order the Planning Commission meeting of June 22nd, 2026. For viewers watching at home, some members of the public may be participating via video conference or teleconference. Please stand for the Pledge of Allegiance. Will the secretary please take roll call?
Commissioner Ferris?
Here.
Commissioner Lanson?
Here.
Commissioner McMahon? Here. Vice Chair Buss?
Here.
And Chair Tyler Kettlehut is absent.
Okay, and so now we're going to have a comment from Planning Commissioner Don Lanson.
Thank you, Chair. In my 9 years of service as the Planning Commission, I've had the pleasure of working with many, many wonderful members of our staff, one of which is deciding to seek better pastures in Arroyo Grande, and I just wanted to thank Kristen Rice for all that she's done for our Planning Commission and giving us such great information for our city. And I'm so happy for you, and Arroyo Grande is very lucky to have you. But again, on behalf of all of us, I don't know if you guys have comments, thank you so much for all you've done for us and for the city. Really appreciate it.
Tonight we have with us Deputy Community Development Director Fabiola Zella Melliker. Are there any written comments, announcements, or continuances at this time?
There are no continuance. We have a supplemental packet that has been distributed to the commission and posted on the website, city's website.
Now is the time for public comment. At this time, any person may address the commission regarding a city planning matter that is not on this evening's agenda. Should the commission wish to discuss an issue raised by a member of the public, the issue will be referred to staff for scheduling on a future agenda. Anyone who would like to speak under public comments must fill out a speaker card in chambers or click Request to Speak on the agenda to receive instructions before the public comments portion of the agenda is called. The speaker's remarks should be addressed to the commission as a whole and not to an individual commissioner or staff member. Unless otherwise provided by the commission, speakers are limited to 5 minutes. The screen will show you the remaining time you have. And we have one public speaker card, Roberta Nadler. Yes. Second one. And then state your name and your place of residence.
Roberta Nadler, and I live here in Thousand Oaks. And this was just a personal introduction to say hello. And this is my first planning committee meeting that I've ever attended, though I grew up in the area. And I'm just very proud of each and every one of you for all the time and dedication that you have put into making our city wonderful. And I hope to see you at other meetings and learn more about the great plans you have for our community. Thank you.
Thank you. Next, we have the consent calendar with minutes of the May 18th and the June 8th, 2026 Planning Commission meetings.
I have a correction or two. Okay, on the May 18th minutes, on page 1, consultant Amanda Dahms is with BBK, and on page 5, consultants Melissa Peltier and Lauren Henkel are with RRM Design. And lastly, on page 8, speaker number 26's city of residence will be removed, leaving just city not stated.
Do any of my fellow commissioners have any comments or a motion to approve the consent calendar? Commissioner McMahon?
I move that we vote to adopt the 2 minutes that are on the consent calendar. God, I can't talk today. As revised, yes.
All right, will the secretary please prepare us for a vote?
Commissioner Ferris,
Yes.
Commissioner McMahon,
Yes.
Commissioner Lanson,
Yes.
Vice Chair Buss.
Yes.
Motion carries 5-0.
All right, so next we'll move on to 7A, open the hearing for 2100 Upper Ranch Road appeal. Will the clerk please open the public hearing?
As required by law, is hereby open to consider Agenda Item 7A, Appeal of Administrative Approval by the Community Development Department of Lot Line Adjustment PM 2025-70009 between 4 existing lots of record, lots 2, 3, 4, and 15, within tract number 5873, whereby Lot 2 is to be increased from approximately 1.08 acres to 1.322 acres. Lot 3 is to be increased from 1.02 acres to 1.522 acres. Lot 4 is to be increased from 1.07 acres to 1.693 acres, and Lot 15, buffer lot, is to be reduced in size from approximately 7.02 acres to 5.644 acres in the Residential Plan Development Low Density Single Family RPD 0.5 SFD zone, located at 2100 Upper Ranch Road. The applicant is David Turnbull. The appellant is Ninaz Khorsandi.
Thank you. Presenting on behalf of staff is Community Development Tech 1, Matthew Mateo. Before we proceed, do any commissioners have ex parte communications to disclose regarding this item? If so, please identify with whom you spoke, their affiliation, when the communication occurred, and provide a brief summary of the substance of the discussion. Okay. So,
Good evening, Vice Chair and fellow members of the Commission. Staff will be presenting tonight's item on an appeal of an administrative hearing officer's approval of a lot line adjustment. The request before you, before the Planning Commission, is to consider an appeal of the administrative approval of a lot line adjustment involving 4 existing lots of record within Tract 5873. The appellant requests that the Planning Commission reverse the administrative decision. The original request, as mentioned previously, was for a lot line adjustment of 4 existing lots. The table provided shows the existing sizes of each lot and the proposed sizes post lot line adjustment. For some quick background, the larger subdivision of the estates at North Ranch, also known as Miller Ranch, was approved in 2014 through Tract 5873 and other related entitlements. That approval authorized 15 legal lots of record, including 13 single-family residential lots and 2 common area lots. One of those common lots is Lot 15, which functions as the landscape buffer and is owned by the HOA. The current application was filed on December 1st, 2025, to modify lot lines affecting lots 2, 3, 4, and 15. Notice of application was provided on March 12th, 2026, and during that notice period, the city received 3 opposition letters. And because of that opposition, the request proceeded to an administrative hearing on April 30th, 2026, where the hearing officer approved the application. The appeal was then filed on May 11th, 2026, and this Planning Commission hearing was noticed on June 8th, 2026. So tonight, the Commission is considering the appeal of that administrative approval. During the notice of application period, staff received 2 emails and 1 written letter in opposition, which triggered the need for an administrative hearing. And at that hearing, staff presented the report and responded to questions regarding the scope of the request, emergency access, drain-related issues, and the applicable review criteria. A total of 6 speakers provided oral testimony. The applicant spoke in support of the request, and 5 speakers wrote in opposition, including neighboring property owners on Upper Ranch Road. In addition, 1 written statement card in support was submitted by the owner of one of the affected single-family lots. Testimony and support generally focused on HOA maintenance obligations, wildfire safety, landscape maintenance, drainage concerns, and the proposed use of proceeds for infrastructure and landscape maintenance as well. Testimony in opposition focused primarily on the reduction in Lot 15 acreage, the potential loss of the buffer, drainage concerns, and the relationship between this request and prior approvals and private agreements. After considering the record, the hearing officer approved the request, subject to the recommended conditions and CEQA determination. And now I'll walk through the appeal statements and staff responses in 3 groupings. Appeal statements 1 through 3 primarily discusses the project's CEQA exemption and asserts that the request either increases density or should be treated as a modification requiring supplemental environmental review. In response, staff concluded that the entitlement before the city is limited to a lot line adjustment among 4 existing lots. The request does not change the general plan designation or zoning of any parcel, does not create any additional lots or building sites, and does not increase the number of permitted dwelling units in the subdivision. Staff also found that the application does not approve grading, construction, or other physical development. And for that reason, staff determined the request remains categorically exempt under CEQA Guidelines Section 15305A, which is a Class 5, which applies to minor alterations and land use limitations, including minor lot line adjustments that do not create new parcels or change land use or density. Staff also reviewed the project for the CEQA exemptions and found that none apply. Appeal statements 4 through 6 focus on the history and function of Lot 15. The appellant argues that modifying Lot 15 conflicts with the 2013 Memorandum of Understanding, the 2014 staff report and project approvals, and the requirement that the HOA own and maintain the buffer area. Staff reviewed the MOU, the historical staff reports, the tract map record, and the applicable conditions of approval. And staff acknowledges that those materials provide important background and help explain the historic buffer function of Lot 15. However, staff did not identify an operative condition, city condition, or municipal code requirement that fixes Lot 15 permanently to its original acreage or exact configuration. Condition number 18 of Tract Map 5873 requires that Lot 15 be owned and maintained by the HOA, and staff's position is that this would continue after the lot line adjustment for the remaining area of Lot 15. Staff also notes that the MOU is a private agreement and by itself is not a city-adopted entitlement or regulatory standard governing the approval of this lot line adjustment. The request, therefore, must be evaluated under the applicable lot line adjustment criteria in the Thousand Oaks Municipal Code. And for your reference, provided in this slide is the lot line adjustment map. The southern portion of Lot 15 will be distributed between the 3 residential lots as shown by the green lines indicating the new proposed property lines for all 4 lots. Appeal statements 7 through 9 assert that formal drainage or engineering plans were not provided, that the lot line adjustment would directly affect the appellant's property and the buffer area, and that the request is unnecessary because other remedies may be available to the applicant. Staff's response is that the city review of this application is limited to the lot line adjustment itself. The application does not authorize grading, construction, drainage improvements, berm alteration, or new development. Because no such work is proposed as part of this entitlement, formal engineering plans for drainage improvements were not required for review of this application. Staff also notes that 2 easements run across Lot 15 and continue to constrain use of portions of the affected area, including a wastewater easement and a storm drain and maintenance easement. Those existing constraints remain relevant to any future use of the property. And with respect to the argument that the request is unnecessary, staff's position is that the availability of other private or financial remedies is not a controlling standard for approval or denial of a lot line adjustment. The city's review is based on whether the required findings can be made under the municipal code and subdivision standards. And again, for your reference, I have provided an enlarged view of the affected lots. The highlighted orange polygons indicate the 2 easements running horizontal from east to west across all affected lots. Again, these easements will continue to remain in place and will be maintained by the responsible parties. Staff finds that the project is categorically exempt from CEQA under the guidelines sections 15305A, Class 5, because it is a minor lot line adjustment that does not create a new parcel and does not change land use or density. Staff also reviewed the project for the exceptions to category exemptions and found that none apply. Staff also finds that the request satisfies the lot line adjustment criteria in Section 9-3, 303F of the Thousand Oaks Municipal Code. Specifically, the request does not create additional parcels or building sites, does not increase density or development potential, does not create the potential for further subdivision, does not create circulation issues, and remains consistent with the approved tentative tract map, applicable conditions of approval, and the Thousand Oaks Municipal Code. With that, staff recommends that the Planning Commission adopt a resolution, find the project exempt from CEQA pursuant to Section 15305A, minor alterations in land use, and deny the appeal, thereby upholding the administrative approval of PM 2025-70009. And while this concludes my presentation, I, as well as staff, are available to answer any of your questions. Thank you.
Are there any questions or comments from the commissioners for staff? Okay, Commissioner Ferris?
Thank you. Thank you for the presentation and the opportunity to review this with you. So a few questions here regarding the application for a lot line adjustment. Who is applying for it? And there are, if I understand, there are 4 affected properties, right? Who are the actual owners of those properties? And are they applying, in agreement with that? Do we have something on the record that shows that they are in fact asking for this? I
Correct.
didn't see it, so I'm asking.
And I hope the applicant could speak as well. The main applicant is David Turnbull, the HOA president of Estates at North Ranch. And from my understanding, also with the application documents provided, the 3 individual property owners, they kind of all, how do you say, agreed to this project for future improvements that will take place of the site.
So do we have something on the record that states that, I'm assuming Mr. Turnbull is representing the HOA as one of the property owners. Do we have something that states that the other 3 lots, 2, 3, and 4 owners are in agreement with this? Here's the reason. I'm trying to figure it out. If my neighbor applied for a lot line adjustment for my property, I kind of want to be in agreement with it,
Understood.
so.
Yes, so we do have in the application that each property owner consents to such requests. As of right now, I do not have that document to provide you.
Okay. Okay. All right. We'll go from there. I'll ask one more question. I'll ask for the commissioner to go forward. As we were stated before, the MOU itself is a private agreement. One of the things that we're limited to, correct me if my understanding is correct, we're limited in what we can review based on state law on, let me see if I've got that. General plan, specific plan, applicable coastal plan, zoning and building ordinances, which lead to the conditions of approval and that kind of stuff. But that's kind of our box.
That is correct.
Reviewing. Okay. Can you help me understand a little bit about condition number 10 on the tentative tract map approval, which states, all lots shall have minimum lot sizes as specified on the tentative map, labeled Exhibit A, dated November 25th, 2013. Can you help me understand how that condition applies?
Very good question. That condition applies to the map as provided to the city at the time. That's to ensure that it meets the minimum lot size standards as specified in that RPD development standard zone. That's make sure they adhere to that standard. It doesn't lock them into that standard. It doesn't lock them into being whatever size it is in that at that time period in perpetuity. It does demonstrate that it meets the minimum lot size, and they cannot go below the minimum lot size that's specified in the code. So that's just reflecting the actual plans.
Okay. And given that there are 4 properties here, 3 of them are in fact increasing in size, but 1 is decreasing in size, is that something that doesn't confront this particular condition?
It does not affect the condition. Now, the condition just ensures that it does not deviate or go below whatever the municipal code standard is for that lot, which is 7,000 square feet in the code. But these were obviously bigger because they're state lots.
Okay.
That's how we're there.
Let me come back and give the commission an opportunity to ask other questions.
Commissioner Lanson?
Thank you, Chair. Since we don't get many appeals, and I think as what Commissioner Ferris was kind of doing, I wanted to get a kind of a definition of what our standard of review, so to speak, is with regard to this process to make sure that we're all understanding exactly what we're looking at and what is beyond our scope.
The appeal before you is obviously in the staff report itself. It lists the appeal statements. The project itself is a lot line adjustment. That's a very objective review from a city perspective. There's certain metrics that a lot has to meet: lot size, lot width. The setbacks that are on a property that you cannot deviate from. When you consider a lot line adjustment, we cannot create a non-conforming situation. So we cannot adjust the line so it makes the setback non-compliant. And factors such as that, so lot coverage and those things. So basically, the Planning Commission's purview is whether or not these objective standards are being deviated from. And Mr. Duran could probably expand on that.
Yeah, I mean, that's basically correct. I mean, the review of the Planning Commission, it's de novo, so you're essentially looking at it for the first time based on all the evidence. But you're limited to what was previously discussed by state law. There's a limited number of factors that you can take into account, and essentially it's whether or not the lots that are being formed comply with the municipal code and any applicable specific plan in the general plan.
Okay.
And if it is, then it's approved. If it doesn't, it's not.
Okay. Understood.
There's just one other thing. This is a ministerial act, so there's, unlike a SUP or something, there's no discretionary review in this application.
That's where I was going to ask that question. All right. So my second question, you mentioned there's an easement farther down. What does that easement cover? And not the land, but is it for a specific purpose, or is it just a setback, or what does it entail?
Yeah. So one easement contains an underground wastewater line with the maintenance responsibility proposed to transition from the HOA to the owners of lots 2, 3, and 4. And then there's also a secondary 20-foot wide easement for storm drain and maintenance. That would remain under the HOA maintenance responsibility.
Is there anything in that document or any other document you're aware of that would provide any kind of deed restriction with regard to changing the lot size?
No, the only deed restrictions there are is the limitations on development within the graded area of each individual lot.
Okay. And then I have other questions, but it's for the applicant, so I'll save those. Thank you.
Any other questions or comments? Okay. Commissioner Ferris.
Thank you. Let me ask a few more just to get an understanding of what it is. You had mentioned that lot line adjustments, they're ministerial. They're sort of like, the people coming forward and saying, hey, I want to kind of move some of the lot lines around. And you referenced that it's initiated by minor lot line adjustments, right? And there's some language within some of the conditions that we have here about things that are minor are done this way, but things that are more substantial come before the commission in its own path. What in this particular case would, like, where does the city make that dividing line that a request for a lot line adjustment is not in fact minor, it's something that needs to go up, so that I have an understanding of?
If it involved more than 4 lots, then it would trigger the major modification.
So that's the specific definition, is that 4 or less, it's considered minor.
That's correct. Procedurally, there's a difference between more than 4 lots and 4 lots. So the MAP Act actually excludes or exempts 4 or less lots from being another map. So,
but that's the city's language when it uses minor and substantial. That's what it's meaning in this case.
The process changes at that point.
Thank you. You did reference a little bit about this particular. Just wanted you to opine a little bit on this. You mentioned that this does not lead to the potential for future development or subdivision. Can you just opine a little bit about what doesn't in this case and what would if a lot line adjustment?
Could you repeat the question, Commissioner?
There are evaluations that you have to make on the lot line adjustments to where if the lot line adjusted allowed for future subdivision in some case, like then the lot line adjustment could be rejected, correct? Like there's some lot size issues.
Right. Lot line adjustments, well, one, they cannot create additional lots, so there's no more intensity being created or established by moving the lines. There's no development being proposed at this time. We can't speculate as to whether or not there would be a construction activity as part of this review. So if someone comes in and they want to propose something in this area, that would go through its own review and its own process at that time, with its own environmental evaluation and other aspects of the project review. But at this time, there is nothing proposed with this adjustment. So this is purely moving lines, and there's nothing else being proposed.
Okay. Last question I have was about, there is a condition, it was sort of referenced in the responses to the appeal statements. I think it's condition 43 of the RPD permit relating to landscaping and privacy buffer.
Would you like me to read the condition?
That would be great.
Yes. So in writing, it says Lot 14 shall be owned and maintained by the homeowners association and shall be heavily landscaped with plant material to include native and non-native drought-tolerant shrubs and trees in order to provide visual screening for adjacent residences of Tract 4023. There was a typo in that tentative in that development permit condition, citing Lot 14 when it should be 15,
Okay.
as Tract 4023 just sits east of this subdivision.
Okay, that was one of the things I was going to ask about this. So the intent of this condition is to provide conditions of approval for Lot 15.
That is correct.
Is the intention that it only provide landscape and privacy buffering for those to the west of this tract? Or is it intended to, I don't necessarily know which of the neighboring adjacent residences are in Tract 4023.
No, it's intended to provide a buffer between all the adjacent properties. So it was Lot 15, sort of creates an L-shaped open space lot that goes around, and the appellant's property is one to the south. So it was not just the properties to the west, it was the property to the south.
Okay, all right, thanks. I'll wait for further comments after we hear from the applicants and others.
Thank you. And now we ask for the appellant or appellant's representative to speak. Can you please come to the podium and state your name and city of residence for the record? Your team will have 15 minutes for your presentation.
Good evening. My name is Nina Kersandi, and I live in Westlake Village. I'm here today on behalf of my property located at 2020 Upper Ranch Road in Westlake Village and my affected neighbors on Upper Ranch Road. My property abuts 3 acres in length with the south side of the Miller Ranch complex, which is the applicant. In its proposed lot line adjustment application, Miller Ranch's HOA will considerably affect my property because the contemplated LLA is attempting to eliminate pretty much all of the buffer between me and the complex, altering the conditions of approval of the Miller Ranch development. If I can ask Matthew to just pull up that map that shows where my property is. Thank you. There are many points that were asserted by me in my appeal that have been made available for your review and counter arguments by the city in its staff report. After review of the city's report, I continue to support my position and urge you to do the same for all of the following reasons. There are a number of undisputed facts that are worth mentioning in this matter. It is undisputed that Lot 15, which is the one that abuts my property and is the buffer between me and the Miller Ranch, consists of 7.03 acres. That can be seen on the tentative tract map 5873 TTM 2010-70187 RPD 2010-7017, the staff report of 2014, the staff report of 2026, page 3. Lot 15 is intended to be a buffer lot between the Miller Ranch development and the Upper Ranch neighbors. You can see that also in the recent staff report and the TTM 5873 land designation. You can also see that in the referenced MOU and the staff report of 2014. TTM for the development in Exhibit A6 has a lot table that's described Lot 15 as consisting of 7.03 acres and maps it according to the development plans. This you can see in the supplement that was provided today. I have a enlarged copy of what the lot table looks like because it's a little bit hard to see on that supplement if it's a regular size paper, but basically it designates lot 15 as 7.03 acres. It also has the square footage and it also has its use as vacant. And that was in the tentative track map. Lot 15 is also demonstrated as 7.03 acres on the assessor's map. Lot 15 shall be owned and maintained by the Miller Ranch HOA. This argument's been brought up by staff, but there's no dispute that it needs to be maintained by the HOA. No one's disputing that. Lot 15 was created as a buffer between the development and the neighboring properties. No one's disputing that. Every single document, including all the staff reports, say and designate it as a buffer lot. That was a condition of approval. The development was approved with the size of Lot 15 at 7.03 acres, scope and purpose of Lot 15 as a buffer. I'm happy to review all the evidence as well. I have it written down, but for the sake of time, I'll just leave it as here. If you guys have questions, I'll refer to it. The proposed lot line adjustment alters Lot 15 so that there is almost no buffer between Miller Ranch's development and my property. And you can see that in the map that's posted up there. They basically are coming up to the berm, that's right there where the waterway goes, and there will not be a buffer between me and that complex. It'll be like, I don't know, 5 feet, 6 feet, not sure exactly, but somewhere around there. In allowing the applicant to go forward, the main question the city has to contemplate is whether the applicant should be able to circumvent all the information and evidence before it to proceed with its lot line adjustment. That is, should the applicant be entitled to disregard the TTM for the development, the MOU between the parties, which included the city and Andy Fox's involvement, the intention of the community and the development in allowing the development to go forward, the previously resolved conflicts at the heart of this matter, and the good faith of the community in balancing development and neighborhood integrity. When I met with the community development officer and in reviewing the staff report, the city's main arguments in support of the applicant are as follows. Lot 15 is not bound by any lot size, so the city can allow the lot line adjustment in Lot 15. Well, TTM 2010-70187 and the resolutions of 2014-003 and 004 state minimum lot size. All lots shall have minimum lot sizes as specified on the tentative map labeled Exhibit A6 dated November 25th, 2013, except as modified herein. That would be the item 10 that Mr. Ferris was referring to. Lot 15 is listed on the lot map as TTM number 5873, and it's listed with the acreage of 7.03 acres with the square footage next to it. There are no modifications listed in the resolution altering Lot 15 7.03 acres. Lot 15 is also mapped and listed on the assessor's map as 7.03 acres. Lot 15's parameters of 250 feet and 100 feet buffer are explicitly stated in the executed MOU and earmarked on Exhibit A therein. According to this document, according to this city's argument, the city can argue to reduce Lot 15 to 1 square foot. There's absolutely nothing stopping the city from doing that because their principle is that Lot 15 doesn't have a minimum size. Proposed lot line adjustment does not alter any development standards for the development and is a minor alteration to the development of the property. So they are saying Lot 15 is not prohibited by project conditions. Lot 15 was a condition to the development's approval as a buffer, and the proposed lot line adjustment violates this condition of approval as a, quote, buffer lot. between the development and the Upper Ranch neighbors. The proposed lot line adjustment is approximately a huge reduction, almost 2 acres, from its current 7-acre buffer. On the north side of my property, it eliminates pretty much the entire buffer, less the 3-foot berm that runs parallel to my property. This would run against the conditions of approval. Additionally, on TTM 2010-70187, page 31, the Conejo Open Space Conservancy, paragraph number 143 states, open space lot. Lot 15 shall be an open space lot owned in fee by the homeowners association. Staff also discusses future development. As the staff report correctly describes on page 12, this proposed lot line adjustment will change the development of the lots that are absorbing lot 15, as lot 15 would no longer be a buffer lot. It would be a part of the lots that would absorb it, thereby giving those property owners development opportunities in the future. That was not the intended purpose of lot 15 as a buffer and an open space. Lot 15 would, the city says lot 15 would still be owned and maintained by the Miller Ranch HOA. Again, lot 15 can be reduced to whatever the city says according to their argument. The city states that there are no size restrictions on lot 15, even though every document from the TTM to the staff reports of the city of 2014, 2026, and the MOU state its size. As noted on every document presented, lot 15 is known as the buffer lot between the development and the Upper Ranch residents. The purpose, size, and scope of lot 15 is what's at issue. That lot 15 needs to be owned and maintained by Miller Ranch is undisputed. This is the city's argument also that it can disregard the MOU because it was not a party to it or it's not a city document. The staff report admits that the city is aware of the MOU. Not just this staff report, the 2014 staff report explicitly talks about the historical context of this situation and the agreements contained therein. The city cannot ignore this critical agreement between the residents, development, and the city, as the MOU acted as a settlement agreement between them. This MOU is the reason the development went forward in the first place. Having already prevailed against the development, the Upper Ranch residents, in an attempt to be neighborly, found a compromise, entered into mediation with the developer and the city through the assistance of Andy Fox, where they were able to reach an agreement for the development. Lot 15 and its current parameters were one of the conditions of approval between them. If it wasn't for the MOU, Miller Ranch would not have been built. For the city to disregard this through the passage of time, knowing that such a settlement agreement was a basis and condition of approval of the development, would undermine the entire conditions of approval and the trust and integrity the community has vis-a-vis the city. The staff also says, but in looking at the MOU allows, quote, minor alterations to the development that may be necessary. The loss of lot 15 buffer is not minor. Neither is there a necessity in this case to alter lot 15. While the applicant has stated that they would like to raise funds from this LLA, the reality is that according to the city itself, any reason for the LLA is to be disregarded when making an LLA determination. In any event, raising reserves is something an HOA can do, and it does not suffice as a necessity. The HOA has other remedies available to it to raise funds, including special assessments and the like. City planning in Thousand Oaks shapes the community's physical growth, balancing development with environmental preservation. It is primarily driven by the Thousand Oaks General Plan, which aims to maintain quality of life and manage land use. If the city approves the applicant's LLA, it will do all of the following. It's going to undermine the TTM 2010-70187, all the resolutions, inclusive of Exhibit A6, which explicitly states that all lots have minimum lot sizes as specified on the tentative map, with the tentative map designating Lot 15 as consisting of 7.03 acres. It's going to undermine the actual conditions of approval laid out for the development, including size, scope, intent, purpose of the lots, including the buffer of Lot 15. It's going to undermine the intent and purpose of Lot 15 as a buffer, because the principle of the city's argument can basically eliminate the approved buffer between the development and the Upper Ranch residents, since there will be no minimum lot size for Lot 15. It's going to undermine the settlement agreement between the community and development, causing damage to the residents and undermining the integrity of communications, agreements, and efforts to be neighborly to new development in the area. It's going to undermine the Conejo Open Space Conservancy designation of Lot 15 as an open space, and it's going to undermine the integrity of designations and track maps and city documents for conditions of approval, as they have been disregarded by any applicant's desire post-development, disregarding purpose, intent, and policy. I have asked the applicant to drop this application. He has declined to do so. After carefully considering the damage that this loss of this buffer will cause if the lot line adjustment proceeds, I will consider pursuing relief against the development's HOA in the city for impacts to my property and its value, as this LLA application violates the TTM, MOU, and California law. I'm available for questions.
Thank you for your presentation. Do any of my fellow commissioners have questions for the appellant? Okay, Commissioner Ferris.
Thank you. I just want to clarify, and I'm going to ask staff to confirm this on here, but from your perspective, is the lot line adjustment and the green line, would that eliminate completely that portion of 15, meaning that's lots 2, 3, and 4 would come right to the edge of that?
That's correct.
Okay, I'll confirm with staff
course.
as to understand that. I just want to
Of
try and
course.
get a sense of that. Okay, thank you.
Okay, now I would like to call up the applicant team. Please state your name and city of residence.
It's David Trimble, and I'm a resident of the City of Thousand Oaks. Okay. So I'm going to provide a little summary of the lot line adjustment project and cover these main topics here: background, proposal scope, use of funds, a preliminary landscape concept that we've come up with, and then the community engagement, summary of community engagement before the original hearing, as well as in between the original hearing and this hearing. So HOA background, the HOA was incorporated in May of 2014 by the developer of record at that time. CC&Rs were recorded in 2016. The first homeowners joined in early 2000 with the first 5 homes that were completed in that year, and I'm actually one of the first 5 residents that moved into the Miller Ranch development. HOA control transferred to the 15 homeowners and the elected board, myself and my colleagues here, in January of 2024, 4 years after I moved into the community. Prior to that, the developer controlled the HOA and all governance and decisions about the HOA. HOA common area equipment, utilities, landscaping, irrigation, drainage were not well maintained during development of Miller Ranch. R2 Westlake did not complete any improvements to Lot 15 other than a portion I'll show later in the slides that on the west side that was partially landscaped. HOA capital reserve, when we received it from the developer, was at 54% of fully funded level based on the most recent Association Reserves report that was provided to us at the time we took over the HOA. So quite a bit short of its financial goals. The board, when we took control of the HOA finances and condition of the common area properties, we assessed and prioritized critical improvements needed and funding targets to complete these improvement projects with a focus on wildfire protection, safety, security, and beautification of our neighborhood. Lot 15 land, the undeveloped portions of the land, which I'll show in the slides upcoming, was one of the top priorities that we identified, particularly to address wildfire threat to our community as well as the residents of Upper Ranch Road, which also abut up against Lot 15. And then the HOA determined that the sale of a small portion of Lot 15 would generate a portion of the income required to finish improvements on Lot 15, as well as address some of the problems we have in our community. Next slide. So Lot 15 land area, as covered in previous presentations and discussion, is an L-shaped property shown in the slide here in this Google map. And just calling out the portions here, item number 1 is Lot 15, what we refer to as Lot 15 West Side, which you can see from the Google Earth image is landscaped. And there is trees, shrubs, and ground cover and irrigation on that portion of the land. Area number 2, Lot 15 East Side, which we call it, is an unimproved land area, approximately 2.25 acres of land up to the emergency road. And then area 3 down below, which is the LLA area under consideration, is 1.36 acres, and that's also unimproved land. Unimproved land requires frequent fuel modification efforts. Since we took over the HOA responsibilities in 2024, we've done multiple clearances per year, including the one that's required by Ventura County Fire Department. And we're continuing to do so twice a year to keep the weeds and the brush and the fuels at the minimum possible. In 2024, the LOA proposal was discussed with the board and the 3 adjacent homeowners, lots 2, 3, and 4. We had an open discussion with them on the proposed sale of portions of that land to expand the backyard space of their properties. And they agreed in principle to the idea. So in 2025, we actually took the proposal to the entire HOA. We had a formal secret ballot vote, which was recorded in our meeting minutes in 2025. And the majority of the property owners in Miller Ranch approved this project to go forward with the understanding that the proceeds from the lot line adjustment would go directly to the improvement of Area 2 of Lot 15, which is the undeveloped land portion that we've identified that needs attention. And then after the vote of approval from the Homeowners Association, we initiated work with the civil engineering here in Westlake Village, Epic Projects, and submitted our application to the City of Thousand Oaks Planning Department in November of 25. I'll skip over the project scope side because that was covered in the staff report and I think in other discussions. So proposed use of funds, maybe a little hard to see on that screen, but hopefully your screens can show it better. First and foremost, we would use the proceeds to fund the Lot 15 East Side landscaping, drainage, and irrigation, referencing latest state regulations from CAL FIRE, as well as the Ventura County Fire Department publications, many of which we found very informative to proceed with landscaping. Really focused on wildfire prevention. All of our homeowners in our neighborhood, as well as the neighbors I've talked to in Upper Ranch Road, that is a primary concern of everyone, obviously in this day and age. Secondly, we would apply portions of funds to move the south fencing in the south open area of Lot 15 and relocate those fences with a setback from what I call the cement culvert drainage area on the south border of our HOA common area and Nina's property. That cement culvert runs from our main entry all the way to a detention basin on the west side of Lot 15, adjacent to Upper Ranch Road. So we as an HOA still have responsibility to maintain that culvert and make sure it's clear and flowing properly for all storms. A little closer up look at the landscape concept for the east side of Lot 15 that we worked with a landscape architect on. Key design features of the 2.25 acres is, first and foremost, installing bioswales to direct water running off of this fairly steep sloped land, directing it into an already installed V-ditch that flows into our detention basin for retaining all of the stormwater. That's the first step. Second would be installing California native trees, shrubs, and ground cover in the property to help stabilize the soil, prevent the growth of invasive species, and do all this in compliance with CAL FIRE as well as Ventura County Fire Department publications. We'd also put a seed mix of ground cover. There are some new ground covers being developed in the landscaping industry now that are fire ignition resistant. That would help keep the invasive species out of this land. And all of this would be tied into a 100 irrigation system that already exists for our west side landscape portion of Lot 15 that has a master valve shutoff and flow sensing to prevent water waste. And lastly, community engagement, which I took really to heart at the April 30th meeting. But actually, prior to that meeting, I connected with Michelle Fata and Randy Witt of the Westlake North POA that manages all of the North Ranch homeowners' common area properties, but manages that 461 homes, I believe it is, in the Westlake North POA. I met with them on site to review Lot 15 and to show them why we were doing this project and what we were going to do with the proceeds in improving the land area that's undeveloped. And that was a very productive discussion at that time. Then April 30th, we had the public hearing. The meeting concluded with the staff approval recommendation. Immediately after the meeting, we met in the hallway with all of the Upper Ranch neighbors that spoke in opposition to the project, and it was the first time I had actually heard all the feedback that they had. So we agreed to meet the next day. So we met on May 1st at the Westlake North Community Center in North Ranch, and we met with the neighbors. We listened to what all their issues were. We said, thank you very much for this detailed feedback. We understand your concerns. We would like to address them. Give us a few days. We'll come back to you. We met again on May 6th. We met by Zoom in that meeting, and I presented, there was three main issues. One, protecting Lot 15 from further development. And I referenced not only our CCNRs, but the TTM and the RPD for the Miller Ranch development. And I said, everything I see here, I'm not an expert, but everything I see here clearly prohibits us from doing any further development of Lot 15. Our main purpose is really landscaping and stabilizing the undeveloped land, particularly in the case of severe winter storms. So that was number one issue. I said we're very confident that this will be protected land area, not just for our period of home ownership, but for future generations of homeowners in our development. The second issue was one of the homeowners called out excessive use of the emergency road access, which exits out onto Upper Ranch Road. And they said delivery trucks and contractors and community services were flowing out of that gate, and they understood it to be a restricted gate for fire department only, or for evacuation of our neighborhood in case of a wildfire. I admitted to them that I had seen the traffic. It actually flows past my house, which I actually own a portion of the emergency road at the top intersection with Miller Ranch Drive, and I can see it from my house when I'm outside watching the traffic flowing around the neighborhood. So I said, we will absolutely address this issue with the city's approval. We'll put up permanent signs. In the meantime, we will block access to the emergency road with traffic cones and a very clear warning sign to keep people off that road. And we put that out about 3 weeks ago, and I believe the traffic has been eliminated from that road. The third issue was Nina had brought up a request to provide landscape access to her property in exchange for giving up the buffer space that we were proposing to transfer to the existing homeowners. And we did have meetings on that May 8th as well as May 19th. She sent us a concept drawing for that maintenance access, and we provided some feedback, and we haven't completed the discussion on that particular item. That's my presentation. I'll entertain any questions you have.
Thank you. Do any of my fellow commissioners? Okay, Commissioner McMahon?
Yes, excuse me. I want to further understand what Nina meant about maintenance access to her property.
Maybe she's better to explain that than me, but would you like to explain it? Yeah.
Yes, my property runs very long, and so when I have gardeners and we want to do our brush cleaning, and I have mature trees and such on my property, they have to come from Upper Ranch and go all the way to the end of the property to be able to clear that debris. So I did speak to David and say, this is an issue for me. So we tried to find a workaround where I was trying to find an access through the back of my property. Didn't work for them. They came around and came up with another idea to go through the side of my property. Didn't work for me. So we just left it at that, and that's it.
Thank you.
Any other questions for the applicant? Okay, now we will go to public comments. We have one public,
Hold on. Before we get to public comments, there's a rebuttal time for the
okay.
the appellant of 5 minutes.
okay. Nina, you have 5 minutes.
I just want to ask a question. This is a little bit different than standard public hearings, but normally the appellant has the rebuttal at the end. Staff usually provides comments for responding to some of these things, then there's the rebuttal. Is that different in an appeal? I just want to make sure.
I mean, looking at the rules, it's not clear specifically on the timing of that. I mean, if you would prefer to have public comments before the rebuttal time, that's fine.
It's not a matter of preference. I think usually you've got a guide, right, that kind of helps you knowing which goes first. I thought it was the applicant, or the appellant in this case. The applicant has an opportunity to, then we're going to hear public comments and then staff rebuttal, and then I'm assuming we'd hear from the appellant again as a final rebuttal. That's at least what I remember is the standard order, so that's why I'm asking the question.
Yeah, again, I mean, the rules that I have aren't specific on the timing between those two things. So if you would prefer to have the rebuttal time be after public comments, that's fine.
I could prefer to stick with the standard
Okay.
format unless we've got reason otherwise, so.
So I think having the public comment go first, that way both the applicant and the appellant can do their rebuttals. But prior to the rebuttal, should I go to staff for follow-up comments?
You can do that, yes.
Okay. So we're going to go to the public speaker card. Will Chandrakant Patel please come to the podium and state your name and city of residence?
Good afternoon. My name is Chandrakant Patel, neighbor of Upper Ranch Road. One of the comment I have, everything they presented to do the lot line adjustment, they can do whatever they need to do without the lot line adjustment. So why even start with the lot line adjustment of something that we have agreed upon many years back with a compromise between the builders at the time and the residents of the Upper Ranch Road and North Ranch Association. So now, after so many years, they're coming back and they're asking for a lot line adjustment of lot 15 from 7 acres to down to maybe 5 acres. If they continue to do that, the value of our property will come down. You will not have the same appearance and the same value that we have today. So I oppose to the lot line adjustment.
Thank you. We'll now go back to staff for follow-up comments.
Yes. So first, I'd like to acknowledge the appellant's statements. The lot line adjustment is more so a change in ownership in regards to the buffer area. Again, there's no construction being approved with this application. The buffer area still is in effect with the current development limitations of the subdivision of Miller Ranch. And if you'd like, Commissioners, I could state the specific conditions as such. Again, due to location of the easements I mentioned previously and the other development limitations associated with them, staff would not likely support future development proposals within these easements, within these easement areas. As well, this is also, there was proposed development happening in close proximity. It has the potential of eliminating the fuel modification requirements, which actually states that there has to be at least a 100-foot fuel mod buffer area from the edge of the graded development pad of each single-family residential lot. In regards to the MOU, again, staff's analysis is that the MOU is a private agreement between the private parties, which were the original developers and the residents of Upper Ranch Road. That being, and again, it is not a city-adopted entitlement, regulatory document, or a condition of approval. Because the city is not a party to that agreement, it cannot serve as a basis for approving or denying this application. Staff's review is instead based on the city's adopted approvals, code requirements, and the subdivision regulations. And to note, regarding the MOU, in the original development proposal, the applicant of Miller Ranch requested Mayor Pro Tem Andy Fox to serve as a facilitator/mediator for the meetings between the residents and developers, as due to Fox's previous experience regarding mediation between owner and tenants of a mobile home park and citywide rent control process. But he was only acting as such as a mediator. And to go into the comment regarding the assessor's tax map identification of Lot 15, the numbers are there as descriptive terms. They're there to reflect what was recorded to the Ventura County Clerk with the final tract map. Again, with this lot line adjustment, should it move forward, that change will also get recorded by the Ventura County Clerk and then reflected as well in the tax assessors as well. And again, as such, there is multiple conditions laid out regarding within the entitlement for the residential plan development and the tenant tract map. While the CC&Rs of the HOA are not an enforceable living document by the city, I did review them as well, and a lot of the limitations of said CC&R kind of loop back onto these original entitlement conditions. While the certain proposals might get passed through their architectural design guideline review, ultimately, once they come into the city for review, we will review each application regarding the subject development limitations within the Miller Ranch subdivision. And lastly, I do just want to acknowledge and really thank the applicant, David Turnbull, who has been pretty tremendous in this. This was kind of his first go at this and trying to understand and being a responsible person as an HOA board president. So he did spend a lot of time, and I kind of did also spend time with him, educating him and such on certain limitations of what can and cannot be done. And I know he and his HOA are kind of beginning to learn, and they've been trying to ask me plenty of questions of what can be done, because they do not want to violate any city conditions. And I know his talks with the residents of HOA kind of build this neighborhood trust and future relationships moving forward.
Thank you, Mateo. If I could just augment his comments, there was a comment made that the open space buffer lots can be reduced down to up to 1 square foot, and there's an intent behind this buffer area. There'll be a process to request reducing that square footage. We'd evaluate that request if it comes before us, but reducing it down to 1 square foot obviously would not meet the intent of providing a buffer between the Upper Ranch homes and the homes at Miller Ranch. So that's not before us. They're not requesting anything besides what you see in front of you. So if they do, again, if they do want to pursue something more, that would be reviewed, and the process would be exhausted as it is tonight. Thank you.
So questions for staff from the commissioners? Commissioner McMahon?
So that whole development, what is the minimum lot size for the actual development? And then does lot 15 have a different minimum than the rest of the lots?
So we review, in the case of future adjustments, we review them under the RPD Residential Plan Development Standards, specifically, pardon me, Section 9-4, 904 Development Standards, subsection E, lot size, usable open space, and recreation requirements, pretty much stating that there should be an average lot size of 5,500 square feet. So that would be the criteria that we would be regulating, that they cannot reduce any further.
Commissioner Ferris?
Thank you. One question I did ask the appellant, but I want to confirm it with the actual specifications of the lot line adjustment itself. So the lot 15 has this L. The lower part, southern part of the L, lots 2, 3, and 4 would be adjusted to extend into that. My question is that does it extend all the way to the most southern part of that? In other words, fully eliminating that part of the L? That's what I'm trying to get at. I've heard some conflicting things. So.
That is correct, Commissioner. With the lot line adjustment, the new proposed property lines for each residential lot would abut directly at the appellant's property.
Okay, that's helpful. So then in that context, I want to see how does this affect the RPD condition 43, which is about the landscaping privacy buffer. As we said, is the intent of that is to provide buffering to the adjacent residences. And it states that this shall be heavily landscaped with plant material to include native and non-native drought-tolerant shrubs and trees. So is that condition going to then go to the owners of lot 2, 3, and 4, or does that have does the lot line adjustment have the effect of eliminating the need to comply with this condition of approval for that portion of the buffer?
It would eliminate it for these 3 residential properties.
All right, thank you.
I have a question. So when Andy Fox acted as the mediator, he was representing the city, or?
No, Andy Fox at the time was, excuse me, he's a certified mediator. So in that capacity, at the hearing, from the dais, the city council deliberated and thought appropriate to use his skills as a mediator since he successfully mediated the mobile home park closure on Newberry Road, if anyone calls that, the Caneo Mobile Home Park. Obviously a very contentious thing to have happen to the residents there. And because of his success in that mediation, the council at that time thought it'd be appropriate to use his skills, mediate the concerns between the Upper Ranch homeowners and the Miller Ranch developer, and they came to an agreement. But in his capacity, he was acting as his mediator, but not a representative of the city.
Okay. And so then the agreement reached is between the two parties, does not involve the city at all, the MOU?
Yeah, that's correct. The city was not party to the MOU.
Okay.
Yeah, let me just add one point to that. Yeah, I'd want to make sure that we're clear here that the city is not a party to that agreement.
Okay, that's what I'm.
It's not subject to the terms of that agreement.
So the only entities that are subject to that agreement would be the HOA, here, the applicant, and then also the HOA with the appellant lives? Like, who is that agreement between?
I'd have to double check to look at the agreement.
Mm-hmm.
And so I don't know who was ultimately listed as the party to that agreement.
Mm-hmm.
But to be clear, it's not the city.
Okay.
And, under state law, that agreement is not something that the city can take into consideration with regard to approving or denying a lot line adjustment.
And we can't enforce it either, the MOU?
We have no enforcement ability over that. That is a separate agreement between two separate parties.
Okay. Okay. Now, will the appellant please come to give your rebuttal? You have 5. Oh, sorry, 1 second. Commissioner Lanson?
Thank you, Chair. Sorry, just a few quick questions for the staff. I noticed in looking at some of the background documentation, there is the MOU, and then there's other agreement on the time period for rough grading, and it actually has a provision at the top saying a recording requested by. Do we have any knowledge that any of these documents were actually recorded against the properties?
We do not. But I believe what you're referring to is the rough grading. There was some under my review of all the pertinent historical documents, that was some type of agreement that happened between the developer and the residents of Upper Ranch Road. There's some conditions that's stating that grading has had to commence during one phase. So I believe that that document kind of reinforced that.
And did the city have any involvement in that grading agreement?
No.
And just to follow up on one issue, and again, I believe Mayor Pro Tem Fox did not participate in the vote on that hearing. Would that be correct? I think, okay, I don't believe he did, but I didn't know if
He did not participate. He
Okay.
recused
Okay.
himself.
That's all my questions right now. Thank you.
Commissioner McMahon.
So I'm sorry, I need to go back to what was talked about before. So the city required the buffer zone?
No, that was discussed between the developer and the existing residents of Upper Ranch Road.
So the city essentially did not care one way or the other if there was a buffer zone?
Yeah, I can clarify that. As a result of the mediation between the homeowners and the developer, they came to an agreement to revise the track map to include the buffer area. So the developer requested the buffer area. The city did not require it, but then by condition, we stated that that would be an open space buffer lot between the properties on Upper Ranch and the developer's property.
Well, that's speculation, but had he not put in that buffer zone, would the city have required it?
No, it was, we were moving forward with a recommendation for approval of the project as it was designed. The mediation obviously changed that, and a new product was presented to the staff.
So it had originally been okay with the city to not have the buffer zone, and then they added that. Is that correct?
Correct. I do want to preface, we don't have an attachment showing it, but the original concept of Miller Ranch actually had residential properties abutting the neighboring properties of Upper Ranch Road, and that was appealed of concern by those neighbors. And then ultimately, they discussed, and then they redesigned.
I see. Okay, thank you.
Okay, now the appellant may come to the lectern, and you have 5 minutes to rebuttal.
Thank you. I just want to address quickly the staff report of 2014, just by way of what you guys are discussing right now. I've attached it to the appeal, but on page 2, it gives a historical background where basically what had happened is the staff report had voted against the Miller Ranch project. You could see that in the findings of that report. So this project was set not to move forward. And that's why the developer sought the help of Andy Fox, because the development wasn't going to go forward as proposed. And that's when the neighbors of Upper Ranch decided to be neighborly, come forward and find a resolution. That included density, less number of lots, the buffer space, all of that. That is actually in you guys' own staff report of 2014. So if you want to take a look at that, it's there on the beginning pages where they're talking about an introduction. And it talks about the tentative track map. I highly advise you look at that because that was after all the mediation gives the information about what has happened. Okay, a few things came about in the staff report of this last hearing. Staff has asked us to disregard any reasons for the lot line adjustment. So if that's the case, I know the applicant has brought in a lot of information about what they're going to do with the proceeds and what their plans are, but the reality is that all of that, even according to staff, should be disregarded. It has to go based on the lot line adjustment and the conditions of approval. So the other thing is the proposed use of funds. Again, that's also should be disregarded according to staff's own report. The native shrubs and the fuel modification, all of those are already in the conditions of approval that their HOA has to abide by. This is nothing new. Wildfire is something everybody has to protect their property on, and including the shrubs and the modifications. So that's not something in excess of what they're doing. It's actually their responsibility to do that according to the conditions of approval. The easement that staff discusses, the easement is belonging to the HOA and the homeowners. So staff says that they need to get approvals. Well, it's on their own property. Getting an approval on your own property and vis-a-vis your own HOA is really not difficult. And the discussion about future development is very likely in this situation. While they say that it's not before us right now, staff's own report says we'll deal with that another day when it comes up. But the reality is that if you get rid of this buffer, then other laws can kick in to basically develop this property, which is completely against the entire intention of this buffer lot. With regard to the MOU, again, I really recommend you look at the 2014 staff report and take it into consideration, because it says a lot about the involvement and the reason why the developer asked Fox to be involved in this. And the city knew about this. The city referenced it in their staff report. You know, to come now and say, oh, you know, we can't consider anything. It considered it then. It discussed it then. It was going forward with development then. Now, all of a sudden, we're coming and saying, well, we can't consider this and we have to disregard it. It's not very kosher. And then the CCNRs, staff discusses the CCNRs. That's private to that HOA. Has nothing to do with any of us. I'm not bound by their CCNRs, and neither are you guys. So, you know, that's up to them. And lastly, the intent of the buffer. As a homeowner and someone who bought that property with that buffer, and the entire integrity of the community enjoys that buffer and has fought for that buffer, I think that should definitely come here with all the evidence of the TTMs, the lot sizes, and the intention, scope, and idea of what Lot 15 means to all of the community. Miller Ranch does not need to do this LLA. They have other options, and their drainage and their water, and Westlake North HOA did also appear and look at it and say you have to take care of these things.
Okay, thank you. So at this time, do my fellow commissioners have any questions of anyone? Okay. So then I will close the public hearing.
Before we do that,
okay.
Can we make sure that there's no public speakers other than the applicant and the appellant?
Yeah. Is there a public speaker?
Okay.
Okay. So now we will close the public hearing, and I will now open up the floor. Commissioner Lanson?
Thank you, Chair. And it's again, we're not used to doing appeals from a process. This is a difficult situation, and made more difficult by a history of documentation that is not as clear in some areas as the parties may want it to be. What I look at is, again, our first and foremost thing is our job, which is to not act as a legislative body, but to enforce our rules, codes, and regulations. The discussion tonight and the report and the information, I haven't found necessarily that the staff's initial recommendation or initial decision on the administrative hearing was improper with regard to enforcement of those rules, regulations. It looks like they adopted, again, our rules in terms of a minor modification applying to 4 units or 4 properties or less. So I don't see any violations of that would necessarily push me in that direction. What I also notice, and the appellant wants us to kind of look at, interpreting the process to insert a lot of terms that were maybe discussed but not necessarily put into action. At the time of the MOU, there is no provision in there indicating that it applies to successors and assigns. It doesn't say this is in perpetuity, so to speak. There is no deed restriction that accompanied the MOU to make sure that it was clear that this was going to be a permanent prohibition against any building in that area. Whereas in the grading document, which I asked about, there is a successor and assign section which made it applicable to future owners. There was an indication that it would be recorded, which again gives some indication that it was supposed to be permanent. But again, the MOU doesn't have that permanence. And in fact, it says it's for the specific purpose of getting this project approved, not necessarily creating a permanent prohibition with regard to the area. And in fact, acknowledges, is believed or hoped would be that part of the deal. But at the end of the day, looking at the actual documents, I don't see that we have, in my opinion, the ability to act above and beyond our executive body function to fill in those missing gaps with that additional information to say that ultimately, oh, there was a permanent intent to have this be a buffer of 7,000 or 7 acres and keep it as a permanent issue. I don't see that. And again, to me, it seems that, again, the city made the decision correctly with regard to application of our codes, rules, and regulations. So if it's okay, I'll go ahead and make the motion as I go back to the top. I would move that we adopt a resolution denying the appeal, thereby upholding the administrative approval of PM 2025-70009, including finding that the project categorically exempt from the California Environmental Quality Act guidelines pursuant to Section 15305A as a minor alteration in land use limitations.
Okay, will the secretary please, comment? Sure. Go ahead, Commissioner Ferris.
Thank you. I am in complete agreement with what Commissioner Lanson has provided us in the sense of this is a very, with the exception of one small part, and that'll be where I get to in the end. We are, I think, quite limited in what we actually can review. And the challenge of, I think staff rightly points out staff reports and the MOUs are exceptional context for us to understand how we got here. This, if you look at the history, I think I actually sat on the Planning Commission when the first proposal came before it, environmental review pre-zoning, because this was a piece of property that had not yet been annexed into the city. So it was going to be, okay, like if y'all decide to annex it, this is the pre-zoning and the approvals. That eventually went up to City Council, and it stated, I think slightly differently than what the appellant said, is that the city didn't deny it, they just chose to continue the hearing because of a lot of the things and that eventually led to the changes and the mediation and a variety of things that eventually was approved in 2014. Then they went through the annexation process and all that other kind of stuff. So there's a lot going on here with this particular case, so it is pretty unique. Given the limitations we have, lot line adjustments are ministerial. They're very limited in what you can actually do with them, what we have the ability to review, which is limited to our own zoning and building ordinances. And that leads us to whether it's consistent with the conditions of approval. I agree with the exemption. I agree that it doesn't add parcels. I agree that it doesn't increase density. The nature of this wouldn't go beyond the 0.5 units per acre of the density. The potential for further subdivision, there's a condition on it, but I don't see that there is real potential for subdivision. Circulation issues are not there. The one I have a problem with is being consistent with the conditions of approval, and it's mostly with the requirement for significant landscaping in this buffer. All the background tells us there was a reason why this was done, and there was a reason why the applicant at that point made all the changes and why that condition was put in as part of the RPD. And by the lot line adjustment itself would actually change the conditions of approval, eliminating the need to even put this landscaping in, which we talked about was the purpose for why that was there. I'm going to vote against it, but it is extremely narrow. There's so much here that I wouldn't be able to have a challenge with. The minimum lot sizes, all that other kind of stuff that we talked about, I think is consistent. But this is the part, it changes the conditions of approval, so I can't make that finding. So for that reason, I would vote against the motion, but there's all sorts of reasons why what Commissioner Lance has put on the table, I think, is in line with a decision to vote for it.
Okay. Will the Secretary please prepare us for a vote?
Commissioner Ferris?
No.
Commissioner Lanson?
Yes.
Commissioner McMahon?
Yes.
Vice Chair Buss?
Yes.
Motion carries 3-1. Commissioner Ferris dissenting, Chair Tyler Kettlehut absent.
Any aggrieved party who wishes to appeal the Planning Commission's decision may do so by filing an appeal with the Community Development Department within 10 days. Okay, so moving on, department reports. We have no department reports this evening. Commission comments and AB 1234 reports. Now is the time for commission comments and/or any AB 1234 reports. Are there any comments from my fellow commissioners? Okay. Ms. Elia Melcher, are there any follow-up items, announcements, or upcoming issues?
Thank you, Chair. Tomorrow night at City Council meeting, the Community Development Department will have the downtown project public hearing that you heard at your May 18th Planning Commission meeting, and a plan check and inspection for consultant contract for the building division on the consent calendar. On July 7th, there will be the second reading of the downtown project on the consent calendar, if approved tomorrow night. Upcoming items for Planning Commission schedule on July 6th, there will be a public hearing for a proposed addition to a single-family residence in the 1400 block of El Verano Drive, and a public hearing for a proposed religious assembly use in an industrial area on Lavery Court. And that is all for upcoming items. Thank you.
Thank you all. We will now adjourn to the next meeting on July 6, 2026 at 6 p.m.